Hello everyone, welcome you back to our channel. This is Legal Mindset Adeba, and we are continuing with human rights in Constitutional Law 2. As we promised that we are going to handle each right one by one until we finish them. And in today's session, we are going to look at the right to freedom from torture and cruel, inhuman, or degrading treatment or punishment. So, this right is one of the non-derogable rights in Article 44 of the 1995 Constitution, and it is provided for in Article 24 of the 1995 Constitution, which provides that no person shall be subjected to any form of torture, cruel, inhuman, or degrading treatment or punishment. So, if a person like this right is non-derogable, as we said, it cannot be taken away. No person can torture another as a must. This right is absolute. I'm going to give you a number of cases which define this right as an absolute and a non-derogable right. So, if you look at a very technical case of Susan Kibula and 416 others versus Attorney General, one of the issues in this case was that whether the death penalty process was a form of torture, cruel, inhuman, or degrading punishment. And this is what court held. Court held that the condemned prisoners did not lose their constitutional rights of freedom from cruel, inhuman, or degrading punishment given to them in Article 24 and Article 44, which recognizes that right as an absolute right, as an non-derogable right, and that the prisoners were entitled to those articles I have said. And court continue to say that they are not to be subject to cruel, inhuman, or degrading conditions, and that the death penalty created fear, and fear is torture. It is a cruel thing. It was inhuman to sentence them to death and you take a very long period without killing them. It violated their right in Article 24, freedom from torture, cruel and degrading treatment. So, court held that their right was violated and it must not be violated. The death penalty taking long violated their right because it was a cruel act. I urge you to look at an interesting case of Impondo Emmanuel versus Nganwa High School. That case is so technical and it helps you to understand freedom from torture very well. That guy, Impondo Emmanuel, was severely caned by teachers at Nganwa High School. So he went on to report to police. Court held that the severe beating was a violation of freedom from torture, cruel, inhuman, and degrading punishment in Article 24, and Article 44 makes it a non-derogable right. So, Nganwa High School was made to compensate Impondo Emmanuel for all the tortures they had put on him. So, we can now continue to the case of Musa Nsereko versus Attorney General. In Musa Nsereko versus Attorney General, Musa Nsereko was detained by the ISO 17 months without trial. But Musa Nsereko said during the custody he was in, he was subjected to torture and degrading treatment. And court held that Article 24 is an absolute right. No person can torture another. As stated in Article 44, the right is non-derogable. That is the case of Musa and Seko versus Attorney General, case of 2020. You can go on and look at another case of Kakwenza Ukilabasaija versus Attorney General. In that case, court held that freedom from torture and degrading treatment is an underogable right, and no person shall be infringed of such right. I hope, colleagues, you have now heard and got what the non-derogable right of freedom from torture, cruel, inhuman, or degrading punishment is. I urge you to look at more authorities to add on. Thank you very much. This is Legal Mindset at the Bar. Subscribe such that we move together.